When I hear the phrase equal pay for equal work, I think of Lilly Ledbetter. She passed away in October of 2024, but is responsible for changes in the law that are intended to close the gender pay gap. In 1979, Lilly Ledbetter was hired by Goodyear as a supervisor. She worked there for nearly 20 years, and about 6 months before she retired in 1998, she learned that her male counterparts who were performing the same job as her were getting paid thousands more per paycheck. So, in 1998, she filed a charge of discrimination with the Equal Employment Opportunity Commission under the Equal Pay Act of 1963, equal pay for equal work. She initially won her lawsuit and was awarded the maximum amount possible under the law, but this victory was short-lived. On appeal, it was reversed and set in stone by the United States Supreme Court. Why? At that time, in order for Lilly Ledbetter to even bring an Equal Pay Act, she had to file a charge of discrimination with the Equal Employment Opportunity Commission within 180 days from the act of discrimination. The EEOC's long-standing position was that the 180 days starts when you receive a paycheck where the wages are calculated on a discriminatory basis. In 2007, the Supreme Court disagreed, finding that it wasn't when Lilly Ledbetter received her check that started the 180-day time period, but when Goodyear determined her compensation rate. Since this determination occurred prior to the 180 days, Lilly Ledbetter's entire claim was dismissed. The Supreme Court's decision effectively rendered the Equal Pay Act useless for two reasons. First, employees are typically not aware of when these determinations are made about their compensation rate. As a result, they don't know the exact time period when to file one of these claims. The second reason, and more importantly, the law protects against pay disparities. It wasn't as if Lilly Ledbetter was getting paid less than the minimum wage. She was getting paid less than her male counterparts. As a result, she has to know what her male counterparts are being paid in order for her to even have a claim to file at all. Lilly Ledbetter only found out that her male coworkers were getting paid more than her from an anonymous letter 6 months before she retired, 19 years after she started working for Goodyear. Justice Ruth Bader Ginsburg dissented, calling the ruling out of tune with the realities of wage discrimination and a cramped interpretation of Title VII, incompatible with the statute's broad remedial purpose. Justice Ginsburg suggested that, and I quote, "the legislature may act to correct this court's parsimonious reading of Title VII." And that is exactly what Congress did. In January 2009, the first piece of legislation that President Barack Obama signed into law was the Lilly Ledbetter Fair Pay Act. The act codifies the EEOC's longstanding position that each paycheck that contains discriminatory compensation is a separate violation regardless of when the discrimination began. New York has its own Equal Pay Act, calling for equal pay for substantially equal work. You have 6 years to bring a lawsuit under New York's Equal Pay Act, and if you are victorious in your lawsuit, you can receive up to triple in damages from what you're awarded. In 2019, New York's Equal Pay Act was expanded to not just cover pay disparities between genders, but also to cover disparities between other protected statuses such as age, race, national origin, religion, and so on. There are many more. So although Lilly Ledbetter was not able to benefit from her case, you can. If you're not sure whether your rights in the workplace were violated, you should reach out to an employment lawyer immediately to avoid missing any important filing deadlines. And have a happy International Women's Day.